Welcome to the Jurist Law Podcast.
Hi, everybody. Welcome to the Jurist Law Podcast with Kimbrough Stevens and Shane Cox. I'm Matt Skye. Kimbrough serves as managing attorney and Shane as chief legal counsel at Jurist Law Group. With rich backgrounds in healthcare and elder law, they help families navigate the complexities of long-term care, asset protection, and estate planning. Kimbrough, Shane, welcome.
Pleasure to be here today. Thank you.
Let's jump right in. What are some common misconceptions or misunderstandings people have when it comes to probate?
So one thing to understand before you get a misconception is to get the foundation of what the definition is. So probate is circuit court, okay? It's a circuit court of probably where you've passed as an elder. Unfortunately, it's the same type of court where you get evicted, divorced, and a number of other things, change your name. So it is very public. And so the big misunderstanding that we hear of the most is, I went and saw an attorney some years ago and I got my will done and I'm all set. Here's the misunderstanding. The will does not avoid probate. Whether you have a will or you don't have a will, if you've passed and there's a relative or a family member that believes that the asset that was in your name should be in their name, right? Then you have to go to probate. It doesn't matter if you have a will or not. What a will does, it allows the probate court and everybody else to see what your intentions were as to that asset, to see who you wanted to control your assets in the will in the probate court. When you pass, that's the executor or personal representative. And then your will is able to very clearly show what you wanted to do with your property and who your beneficiaries are. But the big thing is, if that's all you rely on, you're going to have your family member or your loved ones, your beneficiaries are going to have to go to circuit court to get all that taken care of.
Now, people sometimes compare probate to an IRS audit. Is it really that bad?
Well, it can be, because let me say this about that. Is your probate a contested matter or not? And that's really what it amounts to. If you are in a situation where people are fighting, then it can be like an IRS audit, because you got to report everything. You can do discovery on assets, and it can get kind of litigious. So the issue there is typically in an uncontested probate, when everybody's getting along. No, it's not like an IRS audit. But if you have family that are not getting along and they want to contest things, you're probably in for a lot of heartache. So that's really the two situations. Otherwise, the one thing about an IRS audit related to probate is it is a public matter. Your creditors have a right to know what the assets are. They have the right to make claims, and those have to be adjudicated. So it's kind of like an open book. An IRS audit is kind of like open book. Well, your assets and all your dealings may be exposed to creditors who are trying to, get paid. So, but probate, if you can avoid it, that's the best practice, because then you can avoid the IRS audit at the same time if you can do that.
Is probate public if you can't avoid it?
Well, it's public, yes. And in the sense that there's public filing, there's a public appointment, there's public documents for distribution. And so, yes, it's a state proceeding in the courts. That's a matter of public information. Every now and then you can have documents sealed. You can redact certain things from time to time. If the family's getting along and it's uncontested, you can waive accounting and inventory, so it doesn't have to be published in the county records. So there are some things you can keep private, but the probate itself is public. There has to be a notice in the paper for creditors to file claims and things of that nature. So there's a mixture of privacy inside of a probate, depending on whether it's contested or not, or whether the family has filed waivers saying we don't need to air those things. But so that's a good question. But generally speaking, probate is a public issue. Yes.
So let's get into how can proper estate planning help avoid probate altogether?
So essentially, there's several different ways to avoid probate. And we discuss this at our workshops to help the public understand some of these concepts so they can decide which way they want to go. As attorneys, we're not going to tell anybody you have to do this. We're just going to give you the options and let you decide. But I'll tell you a few things to help avoid probate. Joint ownership. So if you think of an asset like a bank account, and at least in Arkansas, and you have two people on the account and one person dies, then the other person, by being a joint owner, now owns the asset. that is a perfect example of an asset not having to go through probate. Same idea with beneficiary designations, like an IRA or a 401k or even a bank account, another bank account. You have a paid on death beneficiary or a transfer on death beneficiary. It's another example of avoiding probate. There's deeds and beneficiary deeds and different things you can do to avoid probate. So there's many options. There's ways to avoid probate and protect your stuff. And that kind of falls into trust planning. And you kind of get the whole package sometimes. So probate is easy enough to avoid, but it can be quite costly. Probate is a very, very costly process for your estate because the attorney is able to get a statutory percentage off the top of your estate plus cost. And whatever representative, family member, friend that's actually administering the probate, the person that actually went to hire the attorney, they also get a percentage off the top of your estate. So if you think about that and allowing 6 months to allow creditors to file a public proof of claim against the deceased person, then there's a lot of potential things that shave off an estate. And if a person was ever on Medicaid and they end up in probate, that depending on how much Medicaid paid, that could completely demolish an estate so that no family member or friend will have anything left because the claims have to be paid first.
And who is generally involved in the probate process?
Well, okay, so obviously you have to have an executor or administrator of the estate. Someone's got to be appointed to manage the decedent's estate and to prepare it. There's an attorney typically involved to help the administrator or executor prepare the paperwork. Of course, that's what we do. Every now and then, you might have an attorney also serve as an executor or administrator of an estate. But also, then again, there are heirs. Heirs are folks that are going to inherit from the decedent's estate. And then, of course, there are creditors. Creditors are folks that are owed money by the decedent. And where else are they going to get paid? So they file claims to be paid. And then, of course, those are the basic folks that are involved. But at any event, everyone is entitled to notice of proceedings. They're entitled to be heard and have an opportunity to be heard in proceedings. And so, it can be as complicated. You can have a complicated one or you can have a simple one. And again, it really gets back to the family dynamics of the person who's passed away, whether or not they had a will, whether or not there was a trust involved, what other complexities of the estate there is. You may bring in all kinds of folks, but otherwise just in recap, you have an administrator, you have an attorney, you have creditors, and you have heirs, pretty much.
So we've got the different groups involved. Can you walk me through the steps of probate in Arkansas?
So essentially all those parties that he just mentioned go in front of a judge. I guess that's the other party. And this kind of bleeds over into a misconception. A lot of people think you have to file a will while you're alive if you've done a will for it to be valid. And I don't know about other states, but in Arkansas, you don't. So this is the step. If you have a will, and the person passes, essentially the heir, whoever the appointed, if there was an appointed person in the will, would file actually a petition with the circuit court, as I mentioned earlier, and attach a copy of that will. So that might be some of what people think, filing the will. It eventually does get filed, but not by you. It can, you can file a will for safekeeping, but essentially the first step of the probate process is to file a petition with the will if there's one available. And then essentially, as Kimbrough said, everybody that may be listed in the will is entitled to notice. If the elder that's deceased or the person that's deceased don't have to be an elder. If they owed any money to anybody, the creditors have 6 months to actually file a claim. So you can imagine whatever amount of time it takes on the front end to get everything together. When you get it filed, you have to leave the court case open for 6 months to allow other people to file claims. And then, the attorney or the personal representative for the attorney needs to evaluate whether or not the claims are valid. And essentially, if everything goes right, then, the soonest you're going to have the end of the case, which is essentially giving the property now to the beneficiaries once all the claims are paid. And every step of that is like some petition, some motion. You're looking at least 8 months if no one argues, right? So if anybody needs to sell something, like just hypothetically, If part of the probate estate is a house, but the house is destroyed, so the personal representative may have to go and like borrow money or leverage some other part of the estate to get money to actually pay someone to help fix the house up so they could sell it. Every step of that, getting somebody to help selling the house, every step is some motion or petition. So if all goes well and it's complicated and everybody agrees, it still could be quite long just to get all those documents filed. Kimbrough's alluded to this. If a family member argues or something and comes in and starts contesting, then this could last years.
So you've seen it last years. What are some of the most common holdups you encounter?
Well, disagreement amongst the heirs of what to do with the decedent's property. Because even if the will says equally divide, well, that's hard to do sometimes. How do you divide a piece of property if there's one house on it? You can't divide up the house in pieces. Well, what if there are multiple properties? The family should decide, well, which property am I going to get? What are you going to get? A lot of times if the family can't come to an agreement, then we have to sell everything, because typically the only way to resolve a dispute amongst, the distribution of affairs is just to put it in an auction. And, then that takes time. So really, be honest with you, the biggest issue in most cases is when the family is not getting along together. However, the other issue is if you have a lot of assets in an estate that have to be collected, that takes time. If you're trying to liquidate things and sell things to cash, that takes time. And also, if you have a lot of debts, you have a lot of creditors, well, that takes time to weed through. So the more complex the estate, the longer it takes. The more harmonious the family is, the better it is as far as timing.
What are some of the common mistakes people make during probate that cause these delays? I think we brushed on a few of them, but just to recap everything.
So sometimes if a person tries to, handle the probate themselves, they don't understand the procedure, sending out notices to everybody involved. And so if you fail in the procedural part of probate, essentially you risk the whole case being thrown out, all your time and effort. I've seen that. It's complicated because, as Kimbrough said, the creditors, the beneficiaries, they all have a right to know what you have, which goes back to the public side of it. And so if you don't give them notice or a right to say you have a right to see this, you're failing the steps. And so even if no one ever comes and says, hey, you didn't do this right, or hey, this isn't a valid will, the judges are following these steps. And if you haven't done it right, they're going to they'll throw your case out. You'll have wasted your money and time.
So as we wrap up, is this something that people can ever handle on their own, or are they better off finding an experienced Arkansas attorney?
Well, we always say that, if you don't get help at Jurist Law Group, please get help somewhere, because these are not DIY projects. We go to law school to learn these things. There's always rules, regulations, procedures, local rules, paperwork that has to be generated, written, signed off on, filed, reviewed, approved, and on and on and on. So unless you're an experienced paralegal, most folks can't navigate the process of probate. So unfortunately, it does require attorney representation, probably, almost all the time, unless it's a very simple matter. And what I mean by simple is a very simple estate, probably less than $100,000. And we do those in Arkansas without attorneys. People can file affidavits on their own. But once you really get above $100,000, you're into what we call a full probate. And in those situations, it's not advisable to do it on your own. Now, so you ask yourself, well, then how can I avoid that? Well, if you avoid probate, you can avoid having to have an attorney, I guess. But otherwise, you need an attorney if you're headed to probate. That's pretty much it.
It sounds like having an attorney can help you avoid probate, yes?
That's right. So another way to avoid having an attorney later is to have a good estate plan on the front end with an attorney that understands the laws and how to navigate probate so you can avoid it. So a lot of what we do in this practice is probate avoidance. And we help people avoid the hassle of probate later in life. Absolutely.
As we wrap up, I just want to get Shane's thoughts as well. Any final takeaways?
Maybe it's just stressing the point. Some of the thing that's kind of come up over and over again is that if you tried to do this on your own, it can get very costly. Just because you might need an attorney to plan to prevent probate doesn't mean that has to be expensive. As I said, it might just be one or two different things. Just a small plan, on the front end could save you a lot of money on the back end.
think that's a great point to wrap up on. Everybody, thanks for tuning in to the Jurist Law Podcast with Kimbrough Stevens and Shane Cox. For more information or to connect with our team, visit juristlawgroup.com. Kimbrough, Shane, thanks so much for your time today.
Thank you.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.